Hello and a very warm welcome to Bharata First. You're watching Big Picture with Frank Rouse and Pereira. The Supreme Court in March said that the centre should respond to its Collegium recommendations within a reasonable time frame and favoured the appointment of ad hoc judges in the High Courts to reduce the pendency of cases in the judiciary. A bench of Chief Justice Bobde and Justices Sanjay, Kishan, Kaul and Surya Kant took note of delay on part of the central government in acting on the Collegium's recommendations. It said that on each stage there is a certain thought process and therefore there should be reasonable time frame within which the Union Ministry of Law and Justice should act. After Collegium recommends, they need to reply in specific time frame. The bench said there are certain recommendations which are pending before the government for the past 6 months. In this edition of Big Picture, we will analyze the Collegium system of appointment of judges. Joining me on the program today are P.K. Malhotra, former Law Secretary, Government of India, Satya Prakash, legal editor of the Tribune, and Ranjit Marar, advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of Big Picture. Mr. Malhotra, let me start the program with you first. Let's first try and understand and go through the issue of the Collegium system in judiciary. First and foremost, there have been a lot of controversies surrounding it. There have been attempts made to change the system itself, but they have failed. What are your thoughts?
Mr. Frank, I think this issue is a very important with regard to the independence of judiciary and the functioning of the judiciary and the appointment of judges in the higher judiciary. You see, the Constitution, or for that matter, any act of parliament, doesn't talk about the collegium system. This collegium system, as all of us know, is creation of the Supreme Court judgment itself, starting from the judgment given in 1982 in the case of 1982 in the case of S.P. Gupta, which is known as first judge's case, where supremacy of the executive was maintained. But in 1993, which is known as second judge's case, Supreme Court advocate on record case, where the Supreme Court itself, while interpreting Article 124 of the Constitution, which says that the President should, in consultation with the Chief Justice of India, appoint judges, interpreted the word consultation and concurrence and laid down a system of collegium that once the collegium makes a recommendation, that recommendation is binding on the executive, that is the President of India and the Government of India. Now, since there was a confusion with regard to this also, there was a third judge's case in 1999, which is a presidential reference under Article 143 of the Constitution, which certain clarification was sought, and then a standard memorandum of procedure was finalized between the Government of India and the Supreme Court of India as to how the judges will be appointed, and this collegium system came into existence, whereby the Chief Justice with the four senior-most judges of the Supreme Court sit as a collegium, and on the basis of recommendation made by the Collegium of the High Court, they recommended to the government for appointment of these judges. Now, as I said in my initial remarks, there is a history or there is a background to it. So why this interpretation came this way? When the Constitution talks about consultation, it became concurrence. From 1950, when we adopted our Constitution, to 1973, there was no problem because executive and the judiciary were at tandem when the question of appointments were made. But in 73, when Mrs. Gandhi was the Prime Minister and three senior judges of the Supreme Court were superseded and the fourth in seniority was appointed as the Chief Justice, then probably a tug of war started between the judiciary and the executive. Then in the next appointment also, one senior judge was superseded and another junior judge was appointed as Chief Justice of India. I think that led to the intervention by the Supreme Court in the judge's case in 1993, and the kind of interpretation which was given by the Supreme Court, saying consultation means concurrence and that concurrence is binding. And even if the government is sending back for consideration of the case to the Collegium will send it back with reiterating its earlier recommendation. That recommendation is binding on the government and the person whose name is recommended must be appointed. So this Collegium system came into existence by way of an interpretation of the Constitution through, I would say, a judge-made law. And after this judgment law, I'll just summarize in two sentences. In 2014, government wanted to change it by bringing the National Judicial Appointment Commission, constituting an independent body, and amended the constitution accordingly. But in 2015, the Supreme Court struck it down, saying that it destroys the basic structure of the constitution, because there will be independence of judiciary will be gone, because executive is coming into the way of appointment of the judges. I think probably that kind of interpretation which was given by the Supreme Court now needs to be reconsidered again. I'll stop here and would like to have views of the other panelists also before I discuss the other points on this particular judgment.
Absolutely. So Satyaprakash, let me come across to you now and let's talk about, why there has been no real consensus as far as appointment of higher judges are concerned. It's been elusive, like Mr. Malhotra has just pointed out. Over the years, we've tried to get some kind of a consensus, some kind of a proper system going, but somehow it just hasn't happened. What is the real problem? What is the crux of the issue?
Well, the problem is from one extreme we are going to the other extreme. Mr. Malhotra has already explained what was the system before the Collegium system came into being, because there was an attempt on the part of the executive to in a way to take away the independence of the judiciary, and the judiciary was feeling quite suffocated. Not just the judges, senior most judges were superseded, there were punitive transfers of judges, and that is why the judiciary was feeling suffocated and they wanted to get rid of it. And the step they took was, instead of the executive having its primacy in the appointment, they replaced it with the primacy of the judiciary. Uh, the second thing is, even after that, the judiciary is not ready to accept even a smallest kind of interference by the executive. Executive is maintaining that we have a legitimate right and given by the constitution, and they are rightly claiming so, in the process of appointment of judges to the Supreme Court and the High Court. But because of its past experience, the judiciary in the first place, they replaced it, and thereafter, once they have enjoyed complete independence in the matters of appointment of judges of the Supreme Court and High Court, they are not ready to accept any kind of interference. So from one extreme, we have gone to the other extreme. The ideal situation would be, and which was attempted also in NJSC, that the executive must be given to have some legitimate say in the entire process. Because what is happening is, because of the fact that judiciary has been completely excluded from the process, their role has been left, the only thing that is left out for them, to check the antecedents of the names recommended. That's it. Otherwise, and now what is the problem is, what the judiciary once the judiciary ousted the executive from the process, now they are what they could not achieve through NJSC, that is to have a say in the process of judicial appointments, they are trying to achieve it through IB reports. And that is why in many cases you must have seen many judicial appointments in the recent past. Justice KM Joseph's appointment, it was delayed for several months, and there was a lot of hue and cry. The government is trying to delay legitimate appointments and all. The fact is that wherever you try to deny the legitimate say of the executive in the process, they will try to assert it in different manner, and that has led to a situation where legitimate appointments, and in many cases genuine appointments, are getting delayed because there is no consensus on names between the executive and the judiciary. But having said that, before the names are sent, there is problem of consensus in the collegium itself. The manner in which the collegium has been functioning, and even today more than 400 posts of judges out of 1079 judges in the 25 high courts, more than 400 posts are lying vacant. Why? Because the judiciary, the collegium has not managed to recommend names in the number of names which are required to be sent to fill these vacancies. The number of recommendations are quite less, and the vacancy is quite high, and for that you cannot blame the government. So first is lack of consensus within the collegium, and second, the lack of consensus between the collegium and the government. And this has entire problem has now reached a proportion where if it is not addressed properly, the pendency would rise to maybe to such levels where the present strength of the judges, even if it's doubled and tripled, it will be very difficult to tackle.
Absolutely. Mr. Malhotra, I'll just come to you in a bit about, talking about how is it the people who are suffering as a result of this kind of a situation that we are witnessing in the judiciary. But before that, let me go across to Ranjit Marar as well. Ranjit, as far as, judges of the higher courts or the Supreme Court appointing other members of the higher judiciary, your thoughts on that? Is it not a conflict of interest?
See, what happens is there has been situations in which till 73 and thereafter, after during the course of the emergency, we have seen that it has been functioning smoothly. The judges were mature. They were giving the recommendations for those persons who were sufficiently and more qualified than who had been subsequently appointed. But what happened during the tenure of, unfortunately, during the tenure of Mrs. Gandhi was that certain judges who were appointed initially as ad hoc judges, they were not given the permanent appointments. Their appointments were not extended in various high courts, and thereafter, due to the judgment rendered in Keshavanand Bharati, it so happened that Justice Ray overtook or rather superseded the other few judges, including Justice Khanna. This happened and ultimately resulted in, as Mr. Malhotra said, that it resulted in the first judge's case, and subsequently the transfer resulted in the second judge's case, and thereafter the Advocate on Record Association, which is the third judge's case. A system was formulated by which the appointments were subsequently overtook by the judges themselves, and the five senior judges, including the Chief Justice, they interpreted in such a manner that the executive was totally taken out of the entire system. And it so happened when the functioning became so, what you say, within themselves, it did not become so transparent. And the judges with no such qualities, they are supposed to be judges, were also appointed. We have seen various appointments, including the appointment of, I would not want to illustrate numerous, but then we have seen, as what the Supreme Court itself has said, Justice Karnan's appointment we have seen the issue as so far as Justice Dinakaran's appointment was even taken to the Judicial Committee. Thereafter, we have also seen 2-3 other judges also resigning during the course when their impeachment applications were taken. We have also seen during the tenure of Justice Ramaswamy failed impeachment as well. Two things happen. One is that the once you are appointed, there is no accountability so far as you will have to necessarily go for the impeachment. One. Secondly, the other system is the executive do not have any hand at all. They wanted to have supremacy all throughout. And the judges, the system which they formulated for themselves, the collegium system, was also not functioning the way in which it is supposed to function. That may be because of the personal bias which the judges have. See, we come from different parts of the nation. They may have different views. May have different qualities. They may have different kinds of which they think should be better so far as the appointment to the posts are concerned. Here, what we say is they came up with this NJSE in the year 2014, which was also, according to me, was not a substitute at all for the system which is in existence today. We do not have the participation of the lawyers in the appointment. We do not have the participation of the mass as well. There is no selection. There is no ruling out of the persons who are already in as well. Therefore, what happens is you may have, once it is appointed, you may have only the kith and kin of those who are already there. See, it is not computer system which is functioning. It is all the personal human beings who are functioning here. And once there is bias coming into the system, you may not be able to culminate the rot which is there in the system. Therefore, you may have to have such a system in which there is the inputs from the bar. You may also have to have the inputs from the mass as well. What is the service which the person has done as a social engineer, not only as a lawyer, but also as a social engineer? You will have to necessarily decide what is the mechanism which will have to be given to the executive. The judiciary is afraid. If you give it to the executive, they may take over. But the executive still will have to necessarily have the authority over it. Therefore, they are sitting over the names recommended. this tug of war was happening, the system which is there in existence, and once you recommend and thereafter it is sent back by the executive, then also if you resend it and then the executive sits over it, as is what is happening here today, and how the judges are trying to formulate a situation in which the retired judges are to be taken back for the purpose of the cases being decided. If this tug of war goes on, that would not benefit anybody. There would be frustration and there would be numerous cases which cannot be decided. Therefore, the word
Sure.
consultation under 124 will have to bear the fruitful purpose under Article 124 rather than having the raw being pulled in the tug of war between the executive and the judiciary. Having said this, the judges, if the collegium system they mature themselves, probably the appointment would have gone through. Executive always want, as the Justice Cardoso said, they may want to have the committed judiciary. The meaning committed, is it to the society or is it to the executive? This is the larger question which one will have to necessarily decide.
Absolutely. I think there are some very valid points that you raised there. Let me take the point that I was making forward with you, Mr. Malhotra, as well. In this logjam, in this kind of a situation where there is a tug of war between the executive and the judiciary, and nobody wants to let go of their stranglehold or their stronghold, what do you do in a situation like this? What happens to the judicial system as a whole? Isn't it the common man that suffers the most?
You are right. This tug of war between the executive and the judiciary, or one-upmanship between the executive and the judiciary in judicial appointment. Because of this, ultimately, it is the poor litigant who suffers. The vacancies are not filled up as expeditiously as they should be done. Only very recently, I think last week, a Supreme Court bench has commented that about 100 cases are pending for appointment with the executive. First, the Collegium itself takes a long time in recommending the name, and it is not necessary that the names which are recommended, they are recommended purely on merit. There are other considerations which also go on, and that is why one of the objection raised to this particular system is that there is no transparency and there is no accountability in the appointment through Collegium system. As I said earlier also, till 1973, there was no issue. It is only when the executive started appointing the committed judges, the so-called committed judges, the problem arose and the judiciary itself overtook the process of appointment, having its supremacy in the appointment. But now what has happened? We see that after the collegium system came into existence, now the judges are also doing the same thing. What was the allegation on the executive prior to the collegium system come into existence? So I think system needed to be changed. And for bringing that change, so that all the vacancies, as Satya Prakash also said, almost 400 vacancies on the high courts are pending even as on today. Why this kind of delay take place? There should be consensus between the executive and the judiciary so that appointments are made as expeditiously as possible, which is not being done, and ultimately the litigant suffer. To overcome this, I think the process of National Judicial Appointment Commission, which was brought into by the Parliament and it was struck down the court, there is a need to reconsider that kind of system again so that the vacancies can be filled up as expeditiously as possible. Even in the Supreme Court also, today, I think, according to my assessment, I think there are the 5 big posts which are lying vacant, and within another 2-3 months, there are going to be more vacancies. But no proposals have gone to the government for making appointment even to the apex court. I think this kind of situation needed to be controlled. And obviously, when I'm talking of an independent system of judicial appointments, more particularly in the higher judiciary, obviously the judiciary must have an upper hand in making this. But you cannot say that the executive cannot have a say at all in appointment because it will lead to committed judiciary. I think this is a misnomer. The word committed judiciary or going away or giving away independence of judiciary simply because a representative of the executive is there itself is a misnomer, and probably that must go. When you are talking of independence of judiciary, you are talking of decision making process itself. That if there is an interference by the executive in the decision making process, you can say that there is an interference in the judicial work. But simply because executive is making an appointment itself will not amount to interference by the executive in the judicial functioning. And ultimately, I'll go a step further. I'm taking an extreme view. Who makes the appointment of all the judges? It is the President of India who makes it. Who is the President of India? He is head of the executive. So executive's involvement in any case will remain. Only thing is, while names are recommended, the primacy should be available to the judiciary, and that way the collegium, replacing the collegial system, the proposal which was made in the National Judicial Appointment Commission, I think some similar kind of thing, because that has already been struck down by the court. So therefore, we have to respect that. So it needs to be reviewed, and what better mechanism can be there, which is an independent and transparent mechanism for making this appointment, needs to be worked out. And I think this is very important if we really want that the faith in the judiciary which a common man is having today is not diminished.
Absolutely. And Satyaprakash, since we are here then, is there a middle ground? Can you see light at the end of the tunnel? What could possibly be the middle ground?
See, middle ground, I don't see it in foreseeable future that it can be reached. Why? Because the judiciary has taken a very extremist view of the situation. Because it's not a question of independence anymore. What they are seeking is supremacy of the of the Collegium. That cannot be the view, because the government is not saying that we should be given supremacy. In fact, across the globe, you can analyze all the judicial appointment systems. There is nowhere in the world where judiciary itself is involved in the appointment system. It is always with in the hands of the executive, and thereafter. But are we going to say that the judiciary in the US is not independent because the president makes the appointment and Senate does the confirmation process? No. And there is no involvement of the judiciary in the appointment process. In fact, in the UK also we have a new Supreme Court since 2010. There also the involvement of the judiciary is very minimal. So I'm saying the system across the globe is such where the involvement of the executive is a must. Here we have taken an extreme view. So from one extreme we have gone to the other. Maybe it will take a decade or so for the judiciary to realize that they need to understand the requirement of accommodating the views of the executive. Because if you don't accommodate them, as I told you in the beginning, the government is trying to achieve certain things which they could not achieve through NJSE. Now they are using some IB reports and some other things to delay the appointments and to have a sort of bargaining chip. Ideal situation would be NJSE or similar things can be revived. Why? Because in the last 5 years, the verdict came in October 2015. And thereafter, there was another verdict in December 2015. There were two Constitution Bench verdicts on NJSE issue. The Supreme Court itself, the Constitution Bench itself recorded that Collegium is not functioning in a transparent manner. So the problem is the first layer of problem is that there is no involvement of the executive. That has to be addressed. One. Second, even if you don't address that in the current system, that is Collegium system, the Collegium needs to function in a transparent manner. We don't know who is being appointed and why somebody is being appointed. What is important is more than who appoints judges, how a judge is appointed, what are the parameters, on what parameters somebody is being chosen. That should be made public, and people should have a right to know who is being appointed and why. So long as the process of appointment is not transparent, it doesn't matter who appoints, the government appoints or the Collegium appoints. For us as citizens, we are aggrieved that the entire process is opaque and we don't know who is appointed and what are the considerations for appointment. So at least, even if we accept that Collegium system is here to stay, the Collegium and the Supreme Court must follow its own verdict. There was a verdict in 2015 when the Supreme Court struck down NJSE and the 99th Amendment. They recorded that there is problem in the Collegium system. They said that there shall be a secretariat for the Collegium. None of the directions issued by the Supreme Court Constitution Bench has been implemented. I am saying at least implement those verdicts, those directions, so as to instill a sort of some sort of credence or some sort of confidence in the people that they will have in the Collegium. And then second is that whatever may be the system, at least you appoint judges. You cannot be sitting on the files, and you don't recommend, as Mr. Malhotra has pointed out, there are vacancies in the Supreme Court. And there are further vacancies. In fact, this month the CJI is retiring. There are some other judges who are retiring later this year. So why can't we, the Collegium, send the names in advance so that it can be processed the day some judge is retiring, the very next day a new judge comes, so that people don't suffer.
Absolutely, absolutely. And since we are here, since we are talking about how the people should not suffer, Ranjit Marar, is the ball now in the judiciary's court to do something about this? Should they, act a little more responsibly? Like everyone on this panel has already mentioned, that the system was working till about 73. Is it time now, for the judges themselves to pull up the socks and try and get this sorted?
With the system in place, this is the only solution, I would say. They will have to necessarily, what do you say, perform responsibly, because that is what is expected. It is not as if you have to do this. It is whenever you perform, you have to perform responsibly. That is what is expected of the judiciary. You are performing one among the bestest of the jobs which is destined to you. It is not because you get it, but there are only few who are destined. You will have to make sure. Say, for example, it was Justice Lodha. When Justice Lodha was Chief Justice, he handpicked certain judges, certain good senior advocates from the Supreme Court, and they were made judges. We have seen how the quality has made, what you say, that is there for us to see as well. Justice Nariman was appointed during that tenure. We had Justice Lalit. We also had Justice Indu Malhotra. All these people were there. Now, the solution, according to me, would be once it was recommended when Ramjit Malani was the law minister as well. He said we should have a national judicial service rather than having people who want to be taking a place, like having being becoming judges as a heaven for an incompetent person. We do not have good lawyers. These people only want to make through to become judges and have a wonderful life for themselves rather than not contributing anything for the society. But there is a class of lawyers who first become good lawyers and then sacrifice the remuneration, the revenue, etc., and the other perks which comes with being a lawyer. They sacrifice it, becomes a saint, and then serve the society, being the judges. We will have to have such kind of people, and the collegium will have to necessarily make sure that such people are only recommended rather than the chamcha walas, rather not the kith and kin of themselves. One should not be back scratching themselves to make sure that you are so and so comes in place in the high court, and thereafter he will come in the collegium and then recommend the recommended person's relatives. That should not be the thing happening. First, you will have to make sure that there are lawyers who become competent to sacrifice their life to be good judges. For that, the only solution, according to me, would be national judicial service who want to become judges, or make sure that you have some parallel system by which you can select them, and this collegium system ultimately vanishes to have an institution who will always be recommending, whose main process would not be deciding cases but would be only building a parallel system of recommending judges. That should be their main purpose of existence itself. Otherwise, what happens is you will always see, unlike US, the problem is this: US, the president appoints judges, but all the judges sits together to decide whether the case is to be taken on files, whether there has to be a question of law decided as well. Here, what happens is you have two judges or three judges sitting together, and therefore that is where the committed judiciary becomes a little lucid and takes places into zones which we do not want to have at all. That's what I think.
Absolutely. Okay, time to get quick closing comments now from all my panelists with the best way forward. Starting first with you, Mr. Malhotra. Best way forward.
Well, I think the collegium system has already outlived its utility. As has been said, even some of the members of the collegium, after they left the collegium and they retired, they also said that the collegium system needs to be reviewed. And I think when you review it, the process which was taken up under the constitution by amending the constitution and constituting a national judicial appointment commission, some similar body needed to be constituted again with an independent headquarter where the names are sent by the people, from all sorts of people, by the government, by the judges, where it is compiled and then this independent body takes a view on that. Of course, whatever procedures are being now followed under the standard, under the memorandum of procedure, they also need to be followed. But the legislature has to come forward and pass a law to this effect, because as earlier, the judiciary interpreted the law and took the power to itself. Now the legislature should come forward and pass a law in conformity with the constitutional provision, so that there is a transparency, and accountability in the appointment of judges in the higher judiciary.
Satya Prakash, very quickly.
Yeah. The collegium system needs to, first is it needs to be replaced with a new system. And what can be that system? There is a template available in terms of NJAC. It can be tweaked to accommodate the concerns of the judiciary, and it can be made workable. Second, so long as this does not come, the existing system needs to be reworked. I'm saying the collegium must come up with a transparent system, the procedure, because the memorandum of procedure, it's not that transparent. That is when the recommendation reaches the government. Thereafter, how it can be worked. But so far as collegium is concerned, there has to be a system within the collegium through which they can function in a transparent manner. They can process the names in a transparent manner. And the most important part, it's not who appoints the judges, how a judge is appointed, and the parameters on which a judge is selected. That should be made very clear, and it should be publicized, so that you and me as citizens of this country come to know about the people being appointed and why somebody is being appointed. And also, in many cases, very genuine candidates are deliberately overlooked. That should not be done, because ultimately we as citizens have a stake in the entire system, and we have a right to know why somebody is being ignored.
Absolutely. And Ranjit Marar, close the show for us with your concluding remarks.
What everybody is on the same board when we say that collegium system needs to be needs to be dissolved. Till such time it is dissolved, all I can say is, let us have big men with only small egos. They have to perform as mature men, responsibly which you are expected to, rather than having the responsibility as a prefix for yourself. You perform as judges, go by the constitution, and then there will be good appointments. That is what people will have to do. That's it.
Okay, all right. On that note, then I'll call it a wrap on this edition of Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. What's coming out of this discussion is that there is a massive shortage of judges in the higher judiciary, as vacancies aren't being filled up due to the tug of war between the judiciary and executive. The judiciary does not want any interference from the executive, and the executive on its part wants to be a part of the appointment process. The stalemate is hurting the common man the most. Genuine appointments are being rejected as there is no consensus. A lack of consensus within the collegium and between the executive and the collegium is hurting the judiciary. Going forward, we need a system that works, one that is transparent and foolproof. The judiciary should have the upper hand, but the executive must also have a say. Thank you once again for being here. Remember to like and subscribe to Bharata First on YouTube. Ensure that you click on the bell icon and then select all notifications. Do follow the social media handles as well. I need your support now more so than ever. Please spread the word, and see you again next time.